Good evening and warm welcome to everybody present here. I welcome you all the members for the CPA meeting on Benami law today. I would also like to welcome our distinguished chief guest and dignitaries present here. So I would like to welcome Mrs. Revati Raghunathan, Chairperson of SIRC of ICAI to the dais, ma'am. And I also welcome CA Abhishek Murli, Regional Council Member, to the dais, sir. And I would like to welcome Advocate CA Ashwani Taneja, sir, to the dais. And I would like to welcome NV Vasudevan, sir, to the dais, sir. And I also like to welcome Vandana Sagar, ma'am, to the dais. PCIT. Yeah, I would like the members to rise up for the ICAI mottos.
य एष सुप्तेषु जाग्रति य एष सुप्तेषु जाग्रति कामं 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 कामपुरुषो पुरुषो निर्मिमाणः निर्मिमाणः तदेव शुक्रं तद्ब्रह्मा तद्ब्रह्मा तदेवामृतमुच्यते तस्मिन् लोकः शतः सर्वे तदूनात्यति कश्चन एतद्द्वैत 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 एतद्द्वैत.
Thank you. I would like to welcome Chairman of SIRC of ICAI, Revati Raghunathan, ma'am, to address the welcome speech.
Good evening, everyone. A very, very warm welcome to CA. I would prefer to say CA Advocate Ashwani Taneja, sir, not Advocate CA. So here you are the Chartered Accountant first, sir. Mr. Vasudevan, past ITAT member. Both of them are ex-ITAT members. Vandana madam, who is the PCIT, who's very interested in coming here and listening to Ashwani sir, and my colleague in the council, Abhishek, and of course to all my professional colleagues here. Having a session on Benami Act to be addressed by Ashwani sir is something, something to be looked forward to by all professionals, especially chartered accountants. Advocates may be dealing with it on a day-to-day basis, but for chartered accountants, we need to know what is the impact of all these financial transactions, which most of us, take it as a part of our course of work. Whereas what exactly is the impact of some transactions, suspicious transactions, or transactions where money is diverted, where there is a trail of money, where there is a layering of all the transactions, how exactly, it's a very complicated act, a very complicated process, and we need to attend sessions such as this where experts like people who are sitting here on the dais are actually able to are actually handling on a day-to-day basis. Now, if you tell me that this is layered, this particular transaction is layered, I'll wonder why, what is happening, how is it layered. But the layering is the basic part through which these transactions act. And from Benami, you have the anti-money laundering which is coming into play. So I think that, we need to have more such sessions which enable us to understand, because while we do the audit, we are all experts in audit, and we will be able to identify many things, but the work doesn't stop with the identification of that particular activity. The work actually begins there. It is from there that we actually know and understand in which route we are going to take this particular activity. Because you all know that we are also a part of the reporting entities, and we are supposed to have identified and reported. There is a lot of responsibility which is cast on us, and which we should understand and actually take it forward in the right manner. Because whatever is any misdemeanor or whatever happens, the first things which anyone asks is, where is the audit report? What did the auditor find? What was the auditor's recommendation? A small simple internal audit report, a small 25,000 rupees is pilfered somewhere. What do the clients ask? Is it there in the auditor's report? When it is the case for such a small amount, just imagine when crores and crores, lakhs of crores of monies are actually being, triggered away from the country, or triggered and brought back in some manner. How is that happening? That we need to know. And I'm not an income tax expert. I told the people on the dais also, I don't deal with income tax, but I do deal with the darker side of the transactions, not in Benami. Okay, my transactions are the insolvency matters, where the money has already been taken out. So for me also to have an understanding of how the Benami or the anti-money laundering is going to work, because ultimately the ED is going to come into place, and we are going to have our interactions with the ED. And all these are actually dreaded words, sir, for us as chartered accountants when we say ED is coming or this is a Benami Act. These are all dreaded words. What we would like to do is to finish our audit in the normal course of business and move on to the next assignment. So I should say thank you very, very much for accepting our invite and coming here all the way from Delhi to share our knowledge. And along with him, he brought two luminaries also, Mr. Vasudevan and Vandana ma'am. I wouldn't say to support him, rather to share their knowledge and experience also with us. Thank you very much, sir.
Very, very warm good afternoon to one and all present here. It takes me great pleasure and privilege to be having the opportunity to be part of this meeting on this very, very important act. We have with us the chairperson, Revati Madam, our speaker, Advocate CA Ashwani Taneja sir, N.V. Vasudevan sir, past Vice President of the ITAT, and the current Principal Commissioner of Income Tax, Vandana Sagar Madam. See, this topic, Benami Act, is an extremely important topic. It's an emerging area of opportunities for chartered accountants that most people are not well versed with. You see, much like when the 26AS first came out, the Form 26AS, it proved very impactful in bringing out the income that a lot of people were not offering. Then after that, the AIS-TIS came. You see, I still remember, I had a client who has been filing with returns with us for 25 to 30 years. 25 to 30 years. He's been filing with my parents for years, then with me. This person, when he came to file the returns, not only he's been filing for the last 25, 30 years, I think he's paying the same fees also for the last 25, 30 years. So he said, sir, I'm going to increase your fees by 50 rupees. Not because 50 rupees I can do anything or he can do anything. 50 rupees I'll increase just for the sake of showing, sir, inflation affects chartered accountants also, like that. So I said, sir, we are increasing the fees by 50 rupees. Immediately, Abhishek, how you can increase it by 50 rupees? So much money. I am a middle class person. How I can afford it? I said, sir, 50 rupees, sir. If you park in the building today, they cost 50 rupees, sir. No. You know, I have been filing for 30 years with you. Your grandmother has cooked food for me. That and all not relevant, sir. Why you are saying all that? No. 50 rupees too much. What is this? After 2 hours, he left the office without paying that 50 rupees. Next year, he is coming to file the return of income. We now have the AIS and TIS. Now, as you all are aware, AIS, TIS compiles the information from various sources. From SRO, if you have purchased or sold property. From the banks, if you have any savings bank interest, FD interest. From SEBI, NSDL, CDSL, if you have sold any shares or you have got any dividend. Everything comes to the income tax. So this person who has been filing for 35 years, very honest, my grandmother's made food and all, but he cannot afford 50 rupees. I open the AISTIS. He has sale of securities, 85 lakh rupees. He has never told he has Demat account also in 35 years. So I asked him, I said, sir, have you sold shares for 85 lakh rupees? His response was not yes or no. His response was, sir, how you found out? I said, you forget how I found out, whether you have done it or not. Sir, but iduvaraikum na kaatnade illaya, sir. I have never shown till now. So this is the level of Harish Chandra we have in our economy, so to speak. So when this is the case, with the advent of technology, when things are moving forward in such a pacey way, you can start seeing the impacts. We all know in the latest budget, they have increased the rebate up to 12 lakh rupees. You don't have taxable income up to 12 lakh rupees. Why they are able to do that? Heavy tax collection, more tax filers, thanks to technology. Now, one of the biggest things which are in the pipeline is the government is planning to digitize land records. They are planning to digitize land records and ownership records. And trust me when I say this, when this happens, it is going to be a Pandora's box for the Benami Act. The Benami Act came in 1988. Our speaker will touch upon it in detail. But it has been talked about only from 2016. 1988, nobody cared. For almost 18 years, nobody looked at that act at all. But from 2016, suddenly the act got prominence. Because of a major amendment that was made, you will find, as our speaker will cover, unlike the income tax proceedings, the Benami Act proceedings is time bound. You cannot go beyond. The act prescribes the specified time. You have to communicate, you have to respond. Gone are the days where you will say, Pakala notice vandapram, let 5 notices come, then I will see. Show cause vandapram padakala. No, those days are all gone. You know, communication is extremely important. There's a very funny story. When Obama invited the Japanese Prime Minister to visit him, Japanese Prime Minister was not fluent in English. So his translator told him, sir, when you land, he'll be there to greet you. You should say, hello, how are you? He'll say, I'm fine, how about you? You should say, yes, me too. So the entire flight, the Japanese Prime Minister is practicing, hello, how are you? Hello, how are you? Yes, me too. Yes, me too. Hello, how are you? Then they land in the US. He comes down. Barack Obama and his wife are there to greet him. And he comes down the stairs. But instead of saying, hello, how are you? He says, hello, who are you? So he says, hello, who are you? Now, Obama is a very witty person, right? So he thinks he's joking with him. So when he says, hello, who are you? He says, I'm Michelle Obama's husband, how about you? But our sir has practiced and come. No, he says, yes, me too. So the clarity in communication is paramount. And you will find that this Benami Act is going to be a huge opportunity for us as long as we learn how to communicate, how to respond, how to properly reply. It's a very, very powerful act. I would say one of the most powerful acts that I have seen. And it's like a tiger, I should say, this act. When you go through the provisions, you will see the kind of far-reaching impact that this act has. And for that, we need a speaker who has a far-reaching impact as well. So we have got with us Ashwani Taneja sir, all the way from Delhi. And sir, if I can share a small instant. When the amendment came in 2016, we had invited sir to address in SIRC back then. It happened in Ambassador Pallava. a program on PMLA and it was Benami. And sir had addressed, and that's when he kindled my interest, in fact, in the Benami law. Ever since I have been taking up more cases, but all the credit goes to him for, encouraging me, and I am still in touch with him. And the tribunal for the Benami Act, unlike the ITAT which is there in Chennai, there's only a single tribunal which is in Delhi. And he is the king, so to speak, in the Benami tribunal. So thank you very much, sir, for taking time out of your schedule. But before we hand over the session to sir, we have with us two very, very important, guests of honor with us. So firstly, I want to request and call upon Shri N.V. Vasudevan, sir, our former Vice President of ITAT. He hails from Chennai, but has been posted across India. And he has fans of people who represent in the ITAT across India, because a very soft-spoken and gentle person. When we argue matters in ITAT, normally the judge is the one who decides how the proceedings go. Certain judges are more strict. They don't want you to speak too much. They want in a very pointed manner. But sir always allows people to speak. He encourages, he teaches, in fact, and a very, very wonderful person. So thank you very much, sir, for your time here. I will request you, please do share a few words with our audience and gathering here today. I welcome you. Please give a round of applause for N.V. Vasudevan, sir.
Shri Ashwani Taneja, advocate and speaker in today's seminar. Revati Raghunathan, of course she is left. Members of the ICAI SIRC, members of the ICAI, ladies and gentlemen. The topic for a discussion in today's seminar is Benami law and its interplay with anti-money laundering, black money and tax laws of India. It's a very deadly combination. Income tax, money laundering, black money and undisclosed income. See, the Indian government's crackdown on black money continues unabated. The black money is a term which is used in common parlance to refer to money that is not fully legitimate in the hands of the owner. This could be because of two possible reasons. The first is that the money has been generated through illegitimate activities not permissible under the law, like crime, drug trade, terrorism and corruption. The second and perhaps more likely reason is that the wealth may have been generated and accumulated by failing to pay the dues to the public exchequer in the form of taxes. The Income Tax Act did not have a proper framework for dealing with all these kinds of situations, and therefore the first law which came into being was the Benami law. The history of Benami law, if you can trace it, is section 81 and 82 of the Trust Act 1882. It permitted Benami transactions in the past. So under the law that prevailed prior to 1976, one can enter into a Benami transaction and it was perfectly valid. If the real owner, if the ostensible owner tries to cheat the real owner, there is a process by which he can go to the court and get relief. So this situation was not very happy for the income tax. So in 1976, they introduced the section 281 capital A. And this 281 capital A, it prohibited any person to file a suit in a court claiming that any property is a Benami property and he is the real owner. The situation continued till 1988 and the position was not very conducive. So there was a law enacted, Benami Transactions Prohibition Act, and it had its own inadequacies in the sense that it declared Benami transactions, it prohibited Benami transaction. There is no mechanism by which one could be brought to book. And therefore in 2016, the major amendment, that is the Benami Transactions Prohibition Amendment Act 2016 was enacted, and This provided a very broad framework for redressal of grievances and also for prosecution of persons who indulge in Benami transactions. And then in 2002, the Prevention of Money Laundering Act was enacted. And then this money laundering is now today is a buzzword everywhere. It's a process by creating the appearance that large amounts of money obtained from serious crimes had originated from legitimate sources. We just now heard Revati speaking about layering. So the money laundering, actually the offense of money laundering is not an independent offense. What happens is an offense under, there is a scheduled offense given in the Money Laundering Act, and if any person is found to be having indulged in a scheduled offense, then money laundering provisions trigger. So this is the way the money laundering provisions operate. And then we have this Black Money Undisclosed Foreign Income and Assets and Imposition of Tax Act. So that act comes into play when a tax resident has assets outside the country. So this is the way in which, the different manner in which the government tries to tackle black money in our country. So today we have a speaker who is well versed in this subject, Sri Ashwani Taneja. Ashwani Taneja was a chartered accountant and later on became an advocate. He was selected as a member of the Income Tax Appellate Tribunal, worked in the tribunal for about 17 months, and thereafter he quit the tribunal to start his own practice as an advocate. And he has developed a fascination for this branch of law, and he is now regarded as an expert in this branch. I think I will leave the niceties of all these laws to be explained by Mr. Taneja. I thank you for the opportunity, and I would now call upon Mr. Taneja to deliver his speech. Madam, I'm sorry, I think Madam has to speak before Mr. Taneja speaks. Thank you.
Thank you very much, Vasudevan sir. Now I request Honorable PCIT, Shri Vandana Sagar ma'am, to share a few words. In fact, I need to tell, ma'am is a very taxpayer focused person. Just last month, under her leadership, we had organized a first ever National Faceless Assessment meeting with the Principal Chief Commissioner of Income Tax, New Delhi, Jahanazeb Akhtar madam, who was also in Chennai earlier. We had organized for the first time an opportunity to share your grievances, your views, the changes proposed under the faceless assessment and appeals. Ma'am was the coordinator and she was in touch with me throughout, and she did a really wonderful job. It was covered in all media. So she is a real taxpayer focused person. Thank you so much, ma'am, for being here, an opportunity for us to interact with you. I request you, please do share a few words, ma'am. Thank you. Please give ma'am a round of applause.
Hello, welcome, vanakkam. Hope I got it right. Respected, thank you, sir. Respected Vasudevan sir. Mr. Murli mentioned that he has fans across. I think 2 are sitting on the dais already. Me and Mr. Taneja. Mr. Taneja, Mr. Murli and Ms. Revati, she's not here. I'm extremely proud and happy and honored to be sharing the dais with the luminaries like Mr. Vasudevan, Mr. Taneja and Abhishek. Revati has already referred to us as luminary, so that's a collateral advantage that has already happened to us. Thank you for having invited me over. So Benami transactions have plagued the economy and society of India for decades now. So the starting point of Benami transactions is money which has not been subjected to tax. Once that is put in motion, it results in proliferation of more and more black money, and then the evils of corruption and black marketing or money laundering and similar evils of the like. And what in turn happens is that the government is deprived of its rightful share of taxes and revenue, which to me as a tax person concerns. Your perspective is different. Of course, my perspective will be different, because that's where the government suffers a good share of its revenue from the public, or where the Benami transactions are happening. So Benami Prohibition Act was brought about in, it was enacted on 19th May 1988, but incidentally came into force on 5th of September 1988, which is the Teachers' Day also. And as Mr. Murli said, nobody talked about it those days. It didn't have that weight. We can say it was like a juvenile statute. It was only in 2016 when it got teeth and came of age, so to say. From juvenile to coming of age was, that the milestone was in 2016. So I'm really glad the Southern India Regional Council is organizing this seminar on the topic of Benami transactions, and more so to have Mr. Taneja as the lead speaker. He's known for his intellectual heft, and also being a very early entrant after 2016. He is now recognized as the pioneer of and exponent of this act. And Abhishek referred to Benami Act as tiger. I would say Mr. Taneja is a tiger of the as an exponent. So a tiger speaking on tiger, that's what we have today. Thank you for having invited me. I thank the organizers, and let's have a good session. Rumba rumba nandri.
Before we move on to the session, as a token of honor, we want to just honor our guests of honor who have come, that is Shri Vasudevan sir and PCIT Vandana madam. I request CA Ramakrishnan sir and CA Bashir sir to kindly come on the dais to honor our can get a shawl, sir. Now I have the honor of formally introducing our speaker. Though Vasudevan sir was kind enough to share some inputs about it, I wanted to formally introduce him. Mr. Ashwani Taneja is currently practicing as a lawyer specializing in the areas dealing with facets of economic, corporate and tax laws, rendering advisory and representation services across various judicial tribunals and forums. He is a former member of the ITAT, a lawyer, and most importantly a chartered accountant. He is also a cost accountant and company secretary, and also holds the degrees of LLB, LLM, DISA and multiple others. He has to his credit more than 25 years of experience. He first practiced as a CA from 1995 to 2006, and then he switched to becoming a lawyer from 2006. Till 2015 he was practicing as a lawyer. Then he became a member of the ITAT when he was invited, continued there for 2 years as a ITAT judge or ITAT member, what we call it, and authored at his 2 years time more than 2000 judgments dealing with large variety of issues of domestic as well as international tax. Then once again he surrendered his membership and resumed his practice as a lawyer, And he's a prolific speaker. As I told you, he doesn't remember it, we remember it, because the reason he doesn't remember, he is doing thousands of talks like this across India. So he is a prolific speaker and has given various interviews on TV channels, on union budgets and various other developments as well. He is widely travelled and has been invited to attend conferences on international tax across the world, including New York, USA, and was also invited by the Chief Justice of the Tax Court of Canada for his membership in the International Association of Tax Judges. He was also invited to speak at Helsinki in Finland, in the 11th St. Petersburg International Legal Forum Congress, and various other international seminars as well. He is now a name to reckon with in the PMLA, Anti-Money Laundering Law, Benami Law, Black Money Act, FEMA and other various litigations in these fields. He is a founder partner of Prudent Law Chambers, and he is regularly appearing across these various forums as well. Thank you very much, sir. He has come all the way from Delhi for this program. Thank you very much for taking time out of your busy schedule to be here. I welcome you, and I request the entire audience to give him a warm welcome. Over to you, sir. The stage is yours.
Thanks a lot, dear Abhishek, our charming, dynamic leader which we have got by God's grace. My first guru in the profession of making arguments, Honorable Shri N.V. Vasudevan. I still recognize those days when I started like a baby starts crawling and then walking. So I started my arguments before this bench comprising of Honorable Shri Vasudevan and Shri P.M. Jagtap. I hope this both the names, whosoever is having any experience with appearance before the Income Tax Tribunal will definitely connect fast. So I was requesting Revati Madam to invite and request Vasudevan sir to take out some time and give the time to the members of Chennai, because the kind of rich experience he has to speak on the art and skill of representation. I think we chartered accountants are not able to grasp that depth. So Abhishek ji, I am requesting you also whenever possible. Yes. I mean, it will be of immense benefit to all of us here. And Revati Madam is not here, but with the efforts of the outgoing dispensation and Revati Madam and Abhishek ji, this could be possible. So thank you very much for inviting me. Vandana Madam, thank you very much for gracing the occasion and coming here. Actually, when I was in Bombay, so she would appear sometimes in the courtroom where I was sitting. So I noted one thing, that with the keen efforts and intelligence, even the matters which are covered in favor of department can be argued in a matter that the bench thinks of, thinks twice before deciding it adversely to the department. So, that showed one thing, that with requisite amount of intelligence if put in, the tax matters can be, developed in any direction. So what is needed is how to do research and how to develop the arguments. That is what we noted. So in one case I vividly remember, my senior was Mr. C.N. Prasad at that time, sir. So it was, matter was said to be covered by the other side in favor of the SSE. So she simply said, ki, sir, give me a few minutes and thereafter if you still find covered, then you can go ahead. So after hearing her some time, so C.N. Prasad ji told me, ki, Mr. Taneja, I don't think we can do it today. Let us adjourn it and we will decide it later. It requires prolonged hearing. So thank you for accepting our request. And ladies and gentlemen, members of the bar, of the profession, and especially Ram sir, who extended his hospitality since morning to me. And whenever I think of Chennai, the first name comes to my mind is of Ram sir only. The kind of institution he has created and the kind of institution he himself is. Because we get an occasion to argue various issues, discuss various complex issues, which are overlapping overtones of where the tinge of Benami is there, PMLA is there, FEMA is there, and something else is also there. Then 4 or 5 tinges are there. Then the kind of discussion which take place between me and Ram sir is really quite enriching. So thanks to all of you for coming here to grace the occasion. In my deliberations, mostly 2 kinds of persons would come. I can categorize into 2 parts. One, those who have come to hear it for their own benefit. First category. And second category, sir, those whom somebody else has sent, okay, go and attend what Taneja is saying and then tell us what he said. So, I mean, the second category, I call it as the category of beneficial owner is different and Benamidar is different. The person listening here is Benamidar, beneficial owner is somebody else. The first categories are the real beneficiaries. So I do not know how many of us sitting here are beneficiaries, real them or Benamidars. So I can carry out one small test to examine it. So those who are in beneficial category will give a big round of applause in favor of SIRC, Abhishek ji and Revati madam to mark this occasion. And would not be hesitant in assuming the vacant seats which are on the front side. That is the first mark of real beneficiary. So it's up to you. The front seats are vacant. Why are you leaving it vacant? Why don't you come forward? Please. Start it today itself. Why to remain backbencher in life? So because you know that is what I am going to deliberate. Now the government is also making shifting exercise, and one of the shifting exercises, those who are backbenchers, they might be Benamidars also. In terms of various transactions also they are examining it like that. The transactions which are being hidden, which are not being done transparently, something wrong is there about them. Check it well. Before I start my deliberations, one thing I would like to mention. Since 2014, I am noticing that there is a sea change in the legal environment in which we are living. And I would not hesitate in saying and summing it up like that. Welcome to the new legal era. New legal world has come into existence since the present dispensation assumed power. Because of introduction of new laws such as Black Money Act and Benami law and reinforcement of existing laws such as PMLA and FEMA. And now recent introduction of bringing out new tax bill which has been recently introduced, which is another feather in their cap, on which Vandana madam is actively working in the task force committee for giving suggestions. So if you have any suggestions, you can please get it noted them, Vandana madam. But whatever changes are there, those changes which need to be further changed or something which is lacking, which needs to be improved. So she is the nodal person in the department noting these changes. So these things, all these things point out only one thing. That it was noted by the government that tax laws are not sufficient to tackle the problems which our economy was facing. They themselves, they alone were not sufficient. Therefore, these laws have been brought out on the platform in the ecosystem of all these laws which are aimed to control the leakages in the system and to remove the parallel economy which has been running for quite a number of decades in our country. And rightly so, because if you really watch it carefully, meticulously, you will find that this parallel economy is also one of the barriers which is stopping us from becoming properly developed country. Apart from other problems which we are facing, this is also a problem which is contributing a lot as a hindrance. So therefore, these laws have been brought into the system. Now, after, if you read this law, you will find that after the introduction of the laws, certain things are going to change. I bet on it, and you yourself will say, sir, how this kind of law can exist. So first feature about these laws is that they do not come in isolation. It's like corona, which came in with along with comorbidities. So if the transaction is such which is having far-reaching implication, they all will attack together. So therefore, and second thing is, every act states, each of the statutes stating that this law is not in subjugation but in addition to the other laws, and also that in case there is any inconsistency between the provisions of this law and any other law, then the provisions of this law will prevail over the provisions of any other law. Now every law is stating like that. So how you will resolve these situations of dilemmas? Next is, so therefore multiple application is allowed, expressly allowed. Next is, the nature of these provisions is that deemed provisions have been made in this. In this particular situation, the things will be deemed like that. Now there are few deeming provisions under the income tax law which themselves are so harsh. For example, deemed dividend. For example, additions made under section 68 or 69. So 3-4 deeming provisions are there, and they themselves are so harsh to bear. And here the entire law is built upon the platform of deeming situations. If the situation is A, situation B will be deemed under the law. If the facts are like A, situation B will be deemed. So under such situation, when the deeming and presumptuous law has been created, which our constitution has not been allowed in our constitutional framework so easily. Therefore, these laws put together, when we have their total reading, only one thought comes to our mind, that to have a peaceful life and peaceful sailing in our business and profession, that what we are supposed to do is now, the way we think, the way we act, the way we work, and the way we live, all these four should change on the part of the people, citizens of this country, businessmen, and also we as professionals in our professional life as well as in our personal life, both. Questions are raised why they are in the firing range, they means the chartered accountants, etc. Why they are also facing the litigation while their clients are facing the litigation or the prosecution or the investigation. Because of this reason only, that we must change, we must realign ourselves. So I will be taking up some of the provisions. Yeah, one thing more. The beauty of these laws is also that the canvas is very vast. The expanse of their scope of operation is really quite vast, beyond any logical, common sense based thinking. For example, under tax law, we understand in the scope of operation is only income. If income is not there, matter ends. But here, if you talk about money laundering, I mean something which you could not have thought it could be money laundering. Even your genuine transactions, so-called genuine transactions of buying a property or selling a property with wrong people, if this transaction happens, I will define the word wrong later on, can also put you in trouble, if not much, but as much, if not more, but as much as the wrong persons would be in trouble. Maybe little less only, just because you did a transaction with the wrong person. Because you could not have envisaged that you are entering into a transaction which could be branded as part of money laundering or Benami. Because the canvas is very vast, the way the definitions have been given under these laws. We will see all those things. So put together all these factors, guide us to think only on one line, that we must change. Change has come. And those who will adapt and adopt, they will survive. Other will face the trouble. So there are more than 26,000 clauses on which a person can be put to jail. This has been given by this research organization ORF. A businessman can be put into jail because of, if you put together all the clauses. You just read that research report, fantastic piece of legislation. Then CBI, ED actions may now follow IT default probes. Why? Because now the way things are being created, they are being designed on a platform where they can cover a particular transaction from all possible angles. As I said, the tax laws were not found to be sufficient. So therefore, they have created multi-agency scrutiny possible. Specific laws have been created. For example, you can refer to section 72A of PMLA, which talks about constitution of interministerial task force, which will deal with all these different laws. Specific section is there under PMLA, section 72A. Please read that whenever you have time. And therefore, using the higher order data analytics, multi-agency is going to be norm of the day tomorrow. Today also it is happening, but there are some obstacles I feel there are there. So therefore, along with simultaneously with the income tax department search teams, all the teams do not reach simultaneously, but in many cases it has happened also. And the reason why it is not getting at the full scale is because probably there are certain teething issues or certain ego issues which are still resolving, pending for resolution. That income tax department, if they will carry out the search, they will think that why should we share the department with other agencies? If other agency will take the lead, for example GST, they will think that only we should take it forward. So like that, leaving those circumstances, now all that, whenever the appraisal report comes, it is also referred to the Benami department by rule. And Benami department is making phishing inquiries in some cases. Okay, you have some loans which has some problems. Okay, notices are issued under section 23 or 29 of or 19 of PBPT Act. This has become quite old news now, but it has become a fresh force because of recent judgment passed by the then Chief Justice Honorable Shri D.Y. Chandrachud, wherein he has disagreed with the earlier judgment of the predecessor CJI, Mr. N.V. Ramanna, and said it calls for a review. So all the litigations which were buried, they have been reopened in one stroke. I mean, hearing completed in 5 minutes or so, and half a page order passed, and 300 pages judgment has been said to be not a good law. So, and Pandora's box have been opened again. Particularly if you read para 7 of the judgment passed by Honorable Supreme Court recently, which says that all the matters which were disposed of on the basis of judgment of Supreme Court in the case of Ganpati, they can be reviewed if applied for by the concerned authorities. So wherever they were disposed, the review is upcoming. In the list you can see every day, so there is a long list of cases which is happening. Then MOUs have been exchanged with SEBI between various departments to share the data. Notifications have been brought out specifically by the ED and by the government to give powers to the various agencies to report the transaction with regard to the money laundering, which is if it comes to the notice of any of these agencies, NIAs, SFIO, state police departments, regulators, DGFT, Ministry of External Affairs, and so many other agencies. You can see the list. This is in addition to those lists which were issued on 2nd May and 9th May 2023, wherein chartered accountants and other professionals have been made as reporting entities. So a thought arose that whether chartered accountants can have also been involved in the money laundering. No, what they have done is that chartered accountants, if they do some transaction in a particular fashion, which in fact what it means is that is the transactions are of a nature which are not being done at arm's length. So there is a relationship more than a client and professional relationship. For example, participating in his bank account, managing his assets. So that is more than a pure client and professional relationship. In those cases, the professional is designated as a reporting entity, meaning thereby he is cast a responsibility to give the reporting of such transactions to the designated agencies, which include FIEU or Enforcement Directorate in some cases. This chimpanzee was attached by the Enforcement Directorate. When I saw the picture in the newspaper, I was also amused as you are feeling amused today. That chimpanzees and Enforcement Directorate, where is the connect? And that is what I was trying to put before you a few minutes back, that it is difficult to imagine a connect between a transaction and any of these laws. And we need to understand it in a refined manner. For example, in this case, what the connect was given by the ED in their order was that there were some violations of Wildlife Protection Act and IPC, because some certificate was forged. So some forgery related sections of IPC got triggered. And both of these have been designated, categorized as scheduled offences in the schedule appended with the PMLA. And if any proceeds are derived from commission of scheduled offences, they are liable for attachment under section 5 of PMLA. And therefore these were the proceeds from commission of those two offences. Therefore ED got the authority to make attachment of these. So see the connect. Then I will also give the small example of this distillery unit. This distillery unit was set up way back in 2005, somewhere in Jaipur, and unfortunately its water treatment plant stopped functioning. And because of that, FIR was filed by the Pollution Control Board in the respective court. Thereafter, the plant was repaired, and indeed nothing was done by the Pollution Control Board. But in the meantime, ED came into picture and issued a provisional attachment order for giving show cause for making attachment of the factory building of the distillery unit. I mean, I was also shockingly surprised, as you are feeling today, where is money laundering involved here? So I was given the copy of the order. When I read the copy, the explanations given were something like this by the ED. You look, when your water treatment plant did not function well, that means, and you discharge more water into the river than the licensed capacity. Capacity was say 50 KL, you discharge 75 KL. So that means this excess 25 KL which you discharged into the river, it led to excess production, and this showed that there was excess production, and this excess production is unauthorized, illegal, illegitimate, and this illegal production must have given rise to illegal sales, and illegal sales must have given rise to illegal profits, and these illegal profits must have been invested in the factory building, and therefore we are attaching your factory building. Welcome to the new legal era, as I said. So, I mean, could any of the imaginations could connect even the, I mean, the people who are responsible for running the factory, if they knew even a bit that the small malfunctioning in the water treatment plant would lead them to, I mean, to this extent, probably they would not have dared to do it, let it happen in any manner. So therefore comes the need of awareness. Not only the buck stopped here, buck did not stop here. NBWs were issued against the promoter directors by the Enforcement Directorate. Mind it, Pollution Control Board was not doing anything. And NBWs were issued by the Enforcement Directorate. And it became very, very difficult to grant bail by us. We had to toil hard. This is a published matter. Then, as I said, that there is a strong combination of these laws. They are not working in isolation. So the entire ecosystem is there of different laws which are working together, which I call it as interplay of these laws. So because of this interplay, a person needs to have a holistic understanding and awareness about these laws. Because when we need to give advisory to anybody today, we cannot give any advisory in an isolated manner. Say for example, he wants to make offer to pay taxes, additional taxes during the course of search. Now it is not that easy that blindly we can make an offer to pay tax. All right, this is the additional income which I am accepting, because the implications are not confined under the income tax law. The implications may arise under these different laws also, about which we are going to discuss today. So it may be quite possible that he may come out of the net of income tax, but he may get himself pushed into the deep dark valley of these laws, which may be far more dangerous and disastrous. Therefore, the awareness, the totality, the understanding of the totality and analysis in totality is sine qua non for the smooth sailing. So here I have put Benami law in the centrifugal, because the agencies, the finding of the agencies is that whosoever is doing anything wrong would most likely be doing some Benami transactions, and so that he can conceal, hide, mask, suppress the information and the transactions. So therefore it has gained good amount of importance in last few years. Just to give you an understanding, small understanding, how multiple application of laws become possible, and in a given transaction how we can evaluate the implications under different law. Suppose a person is doing smuggling, and when he makes reporting, say in his income tax return he is mentioning income from trading, and he earned say rupees 10 crore, full amount of rupees 10 crore he is disclosing therein. So let us see what are the possible violations under different laws under such circumstances. Now as far as income tax is concerned, he has made full disclosures, full tax has been paid, so no problem. Under FEMA, no problem. Under PMLA, because he is disclosing the facts as it is, under my view, no problem. Though ED may take some action, under other laws does not seem to be any problem. But suppose in the same transaction, while doing, he changes his disclosures in this manner and does the transaction in different manner. Say for example, in his income tax return, he is saying income from trading. Instead of saying income from smuggling, he reports income from trading. And out of rupees 10 crore, he is reporting there only rupees 4 crores. 6 crores he is not reporting. And because from this balance 6 crores, 2 crores he is sending abroad to be stashed in his bank account. And the amount left of 4 crores, he is giving it to one B Limited, who in return gives check to his company, say his name is Mr. R, his company R Limited, by way of share capital. And R Limited is issuing in return share certificates to B Limited in the name of B Limited. So let us evaluate what are the possible actions under which he can be booked now. Now since he is reporting, first of all under income tax law, he is under reporting his income, straight away for 6 crore tax evasion he can be booked. Under Black Money Act, he is stashing his income abroad in an undisclosed bank account. So Black Money Act is straight away attracted here. Under PMLA, yes, because he is saying income from trading, whereas it is income from smuggling. So he is converting bad money into good money. Under customs, yes, he can be roped in. Now under SEBI, depends upon whether it's a listed company. If yes, he can be roped in. What about Benami? Any transaction which you could notice here could be roped in Benami also. For example, yes, go ahead. Give your guess. In his company. So B Limited, who is holding the share certificates, is B Limited holding in genuine capacity? holding in Benami capacity. So one transaction, one smuggling, and see how many laws are ready to pounce upon him. So we understand briefly these laws today: anti-money laundering law, Benami and black money. Very fundamental things let us discuss. So anti-money laundering law. Let us start with this fact: money laundering. What according to you is money laundering? Achha, one thing more before I start more on it. I noted one thing when I was reading these laws, be it anti-money laundering law, especially Benami law. So guidance I got was not with regard to only how to comply with the law. The guidance which I could get is how to live your life, what is not to be done in your life, and a holistic approach which comes up, which the way we proceed further, I will be able to share my thoughts on that. And I will be able to show that certain things are, borrowed from that spiritual framework, that the way the provisions have been drafted. And also one thought came to my mind, let me put it before you. A question arose in my mind, an issue arose, that whether there is anything common between law and spirituality, or they are totally different. My senior colleagues are here. Need not answer promptly. Think about it. Let us proceed further, and then by the time we conclude, maybe you yourself get the answer, and if not, then we will discuss and decide at that time. Maybe that is only one instance you are quoting. Much more. Let's discuss about that. So coming back to the topic which we were having, what exactly is money laundering? Any guess? Anybody would like to make an attempt? This is very fundamental. And believe me, in the entire country, we are still jostling with the fundamentals. When I say we, I include everybody. Our departments, enforcement agencies, our honorable judiciary, and we professionals. All three. And citizens also. All four. Yes, please go ahead. No, I said what is money laundering? So earning of money itself is money laundering. That is what you are saying. Anyone else? Okay. Quite close, both of you. Any more attempt?
Washing dirty money, making it white.
So how means washing means what? We do not, washing in washing machine?
The process.
What is that? That is what we are discussing today. What is that process?
And making it illegal. Appearing to be.
Okay.
Actually not. Hiding the source.
Hiding the source. Okay. So if I earn pure consultancy income and I do not tell anybody that I am earning pure consultancy income, that will be amount to money laundering. There is something more to it. That means somebody said that they observed that converting black into white is money laundering. Do you agree? No? Converting black into white is money laundering. Anybody saying yes? Anybody saying no? Anybody saying yes? Converting black into white. Sorry? Yeah, okay. Giving black money as appearance of white. Will it be money laundering? So then what will be tax evasion, sir? So if we want to understand it quickly, symbolically in terms of color, conversion of black into white is akin to tax evasion. So money laundering is much more than that, little more than that. So it will be like conversion of red into white. Here the word red will denote blood, which will denote in turn crime. So something related to crime, white will denote purity, innocence. So something related to crime shown as innocent, pure, is money laundering. In terms of colors only I am explaining. I will explain it legally also, in a proper legal manner also. So various questions which are coming to our mind are these fundamental questions, and believe me, we are jostling with the fundamentals only, and we should first of all be clear on fundamentals only. I went to Kanpur few days back. So one of the gentlemen who was a senior person in the governing council there, from central council, from this CIRC, so he requested, sir, kindly, our members are not yet very familiar, so kindly confine to fundamentals. I said, I have no other option, because I know the fundamentals only. So I cannot go beyond that. And it's not me only, in fact everybody is still jostling with fundamentals only. You pick up any judgment of Honorable Supreme Court also, we are just confined to fundamentals. This is a fundamental that Honorable Chief Justice N.V. Ramanna Saab says something, and CJI, next CJI reverses it, ki whether, what will be the limitation period, whether it is retrospective or not, it is a fundamental question. So even that question is not yet decided. And kindly give me one clear picture or definition of money laundering which has been given by any court so far. No, we do not have proper definition of proceeds of crime. We do not have proper definition of money laundering. We do not have proper definition of few more things, burden of proof under this law. So let us first of all do not be hesitant to admit that. Let us clear our fundamentals. So what is money laundering? Is it different from tax evasion? Whether tax evasion is also money laundering? What are the authorities governing law in India? What is the punishment for offence of money laundering? What are the consequences if provisions of PMLA are invoked? What are the broad powers? What kind of properties are attached as prescribed in PMLA? Whether a property purchased out of any business activity which is not legitimate in the eyes of law can be covered under PMLA? What all things cannot be covered under illegal business? What are the legal remedies? What are the precautions? What is the effect and impact of attachment of property? This is very, very important question. Very, very third question. Then the most of the prominent question which people are facing here is, what is the status of bona fide purchaser? Is he also protected or not? If he has done by mistake a transaction with a money launderer, is his property is gone, his transaction is covered, or what? What is the situation? Then, sorry, this last one, which this unexplained cash credit loan added by income tax into taxable income, can it be covered under money laundering? One of the most prevalent questions. Hawala transaction, how overlapping of multiple offences or laws are dealt with? This is one of the cardinal issues which we have to deal with. Whether statement made by third party about accommodation entry or on any issue, whether the third party statements can be made binding, especially if the statement is taken under section 50 of PMLA. How it is different from statements taken under Income Tax Act? What is the binding force or no binding force? This is the question with which I think almost in every city, every office of ED is grappling with. Defaults in repayment of bank loan, because of which Vijay Mallya had to leave the country and had to go to UK. This is that question. And many cases are going on. More than, I think, 1,000 cases pending in every city. Every major city means major city, every state capital, more than 1,000. Then money laundering. Let us try to understand formally what the money laundering means as per the definition given under the law. Section 3. Whosoever directly or indirectly attempts to indulge or knowingly assists or is knowingly is a party or is actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition or use, and projecting or claiming as untainted property, shall be guilty of offence of money laundering. I feel sometimes many drafts were made of definition. They finally could not be decided. They got tired, and whatever definition was there picked up in the last, they just pasted it here. Because I am not able to make head and tail out of it. What exactly they are trying to say? They are trying to say something near to that. But what exactly is a guesswork. One, and the other thing is, I'll come back to this definition. I wanted to show something more. I'll come to this and then I'll come back to that definition. So there are three stages which I could visualize, understand in the total process of money laundering. Stage number one or step number one or part number one, whatever you may call it, is that there should be commission of scheduled offence. What is scheduled offence? We will understand in detail. But there should be commission of that. That scheduled offence must happen. Somebody should do scheduled offence. Second is, some proceeds must be generated out of it. So money should be there, or money is, it's something valuable in terms of money should be there. Generation of proceeds of crime. And third would be that stage which somebody was mentioning from somewhere in the middle, that there may be attempt of commission of money laundering by placement, layering and integration. That is portraying part. So first is doing the wrong thing, then from wrong thing doing the earning the wrong money, and the wrong money is being portrayed as good money. In law the terms tainted and untainted has been used. So earning of untainted money and showing it as tainted money is money laundering. That is what is can be understood conceptually speaking. Legally speaking, the way they have defined is this definition. So three stages which I put before you, they are cumulative in the sense all of them must happen simultaneously. If any one of them is missing, it cannot lead to money laundering. Now if you see, I have noted the word and because of the last condition, and is there, it's not or, and is there. Then and projecting, so it's not, earning is not enough bad money, projecting it as good money is also required. Otherwise for earning bad money there are other punishments, for example theft, earning money through theft, that itself is a punishment, is a separate offence. So money, stealing of money and showing it as good money is the third stage, which is a sine qua non, and that is why the word and has been used in the main section. But hold on, one explanation has been added. Explanation has been added with effect from 1/8/2019. I think explanation has gone missing from here in this, not no, here it is, sorry. Now if you kindly notice it carefully, they have come back, they are using the word or. Use, after the word use, the word should have been add and to bring it in conformity with the main section. But in the explanation the word or has been added after the word use, as if the last condition is also an optional condition. Meaning the way a person earns through bad means but is not showing it as good money, but that earning itself becomes money laundering, which is not possible under the law, because that is a scheme of the entire scheme and concept of money laundering is that disclosure should be of good money. That is what called as washing. Otherwise washing will not happen, laundering will not happen. So why to say it then money laundering? So there is some confusion because of that, which needs to be resolved. And what is proceeds of crime? Definition is given here. Proceeds of crime means under section 2(1)(u), any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offence, or the value of any such property, or where such property is taken or held outside country, then the property equivalent in the value held within the country or abroad. Here also a lot of controversies are going on because of the peculiar drafting. And the first controversy is that people say, okay, we understand if the money is derived from bad means and invested into some properties, bad money, then property becomes bad property. Or if the property is derived from some bad sources, illegitimate sources, then that becomes proceeds of crime. But what if that property is not available and some other genuine properties are available, whether that can also be attached in lieu of the earlier property? That is a fundamental question which has become bone of contention. So according to my understanding, this definition is clear, because for any property which is taken or held outside country, only then equivalent property can be attached. Otherwise it should be that property or the value of any such property. The value of such property means wherever those proceeds have been invested. So there should be infusion of proceeds of crime. Only that property can be attached. But what is happening in the country today, if you see it carefully, that the Enforcement Directorate is making attachment of all the properties. If all other properties also, if the property derived from proceeds of crime is not available. Just to give you an example, a person did some theft, purchased gold out of that, he sold the gold, deposited in the bank account, from the bank account he purchased shares, sold those shares, invested in the plot of land. So in this total trail, whatever is available can be attached, because the trail is same, selling, buying, and then finally reaching in the plot of land can be attached. Now suppose after selling the plot of land, he sells plot of land also, gets a sum of rupees 1 crore, and this 1 crore he goes to casino and loses all the money of rupees 1 crore. Right? Now ED wants to make attachment, that 1 crore has gone. What the ED can be done? What can be done under PMLA? Some other property can also be attached. Some other property means say some property which he has received from his grandfather by way of a gift. If this 1 crore is not available, that can be attached. This is the question with which litigation is happening all around in the entire country. Any idea, any guess after understanding this section? So according to my understanding, if you read the entire scheme of the act, only proceeds of crime or the property involved in money laundering, that can be attached. So if any other property which is not involved in money laundering, that cannot be attached, because this is not a tax law where tax recovery has to be made out of the estate of a person. No, it is not like that. Only that very property can be attached. But what is happening is, if the proceeds of crime have vanished, the ED would make attachment of any property available with that. And that is giving rise to a lot of litigation. Now what is scheduled offence? So scheduled offence simply means an offence which is mentioned in the list of schedule appended with the PMLA, Prevention of Money Laundering Act 2002. If it finds mention in that, it is scheduled offence. So if any other offence is done by a person, then that will not be categorized as scheduled offence. Any offence which is not mentioned in the schedule, that will not be. So only an offence which is put in the list of the schedule, which includes, the list is quite exhaustive. Prevention of Corruption Act is there, environmental laws are there, mining laws are there, IPC sections are there, and Black Money Act's one section is there, section 50, and Customs Act's one section is there. What about income tax law? Whether income tax is also mentioned, that if in case tax evasion happens, that will also be scheduled offence. Thankfully, no. Why I am saying thankfully? Because otherwise every assessment order will become liable for being acted upon by the Enforcement Directorate. Thankfully, no. But hold on. Income tax evasion as such is not mentioned there. But in the journey of doing, in the process of doing income tax evasion, if any such steps are made by a errant assessee which have led to commission of certain offences which are otherwise scheduled offences, that can take him into trouble. For example, he has done some forgery in this process, some smuggling, some any other such thing. Then because of those actions, scheduled offence can be said to have taken place, and therefore any money derived therefrom, then that can separately be hit under this law. So there are many reasons why experience with the Enforcement Directorate is said to be so harsh. So first of all, I showed the reason that money laundering definition itself is not clear. Proceeds of crime definition, it is not clear. Then I also discussed that scheduled offence list is quite exhaustive. And the most important reason which is mentioned on this slide is reverse burden of proof. Our constitution is based on the concept that a person is deemed to be innocent unless proved guilty, and the burden to prove that person as guilty is upon the person who is alleging him to be guilty. That is prosecution in most of the cases. But this fundamental concept has been compromised here. it's preached. And therefore this specific section has been brought out for reverse burden of proof. But hold on, whether the burden has been completely reversed, entire burden is upon the person who is accused of offence of money laundering, or burden is only partly reversed. As I said, there are 3 stages in the process of money laundering. So do you notice by reading of this section that for all these 3 stages, burden has been reversed? In case of a person charged with the offence of money laundering, the authority or the court shall, unless the contrary is proved, presume that such proceeds of crime are involved in money laundering. So whether, if I talk about first stage, that he has done scheduled offence, is it mentioned that it will be presumed that he has done scheduled offence? No. Is it mentioned that it will be presumed that he has earned proceeds also from that scheduled offence? Suppose a person has done, say, allegations are that he has done some fraud. So whether in that process he has earned something out of it? He has done some hijacking, say, for ransom, something. So whether he has earned something, that is it presumed here? No. Only third thing is presumed, that if he is charged with the offence of money laundering, he does the third stage, that he has done the offence of money laundering, that will be presumed. So if 2 things are established, third will be presumed. But what is happening in practice? All 3 stages are presumed. And that is why the experience has become quite harsh. Because it is otherwise unimaginable if somebody asks and says, hey, look, there is an allegation that you have done some theft, and I am presuming you have done some theft. Now you proved you have not done some theft. How shall he prove the negative? So a person is presumed to be available at the site of the murder if he is accused, simply because I will presume you prove you are not there at that time. So something like that. So that is why it has become very, 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 very difficult exercise to handle. And that is why a deep understanding on the part of the profession is required to handle the situation well. The other reason is web of actions. Whole lot of web of actions would start. Whole lot of web of actions, you can see. So many web of actions. Immediately on triggering the actions, say some action has been taken by the investigation agency. So because of some action having been taken by the investigation agency, the ED will come into picture. And the moment ED will come into picture, it will start actions in 2 directions. One, attachment, other, investigation under section PMLA, and third maybe arrest also. And then trial, and then custodial interrogation, etc., blah, blah, blah. So since so many actions start simultaneously, it becomes difficult to withstand the pressure and handle them well, defend them well, legally. And there are multiple forums also. So many actions, multiple forums. Becomes difficult exercise. So some of the questions which we are facing are like that. For example, in the case of bank default case, which I wanted to discuss with you. Suppose a person does default in repayment of the bank loan. Person means a corporate borrower. Now, because of the norms created by RBI, something like that any person defaulting in loan account, any such loan account has to be categorized as fraud account. It is not fraud account, they are not declaring it as fraud account, but they are categorizing it as fraud account. And so every bank branch has to categorize NPA as fraud account as per the RBI guidelines. So the moment it is categorized as fraud account, there will be imperative reasons with the branch officials to take action against such kind of borrower by filing an FIR before the concerned investigation agency. So investigation agency could be UW or CBI depending upon the ticket size of the loan. The moment FIR is filed, ED will get the power under the law to take action. And the moment ED gets the power to take action, they get the power to make attachments also, apart from other investigation exercises of power and arrest and all that. So it's like that when they make attachment, it can be compared with the situation you pick up an ant and dip it in the ink pot, leave it back on the paper, say 2-3 ants. So wherever their trail would be going, the ED can follow the trail, financial trail of transaction in this manner. So suppose the ticket size of rupees 1000 crore which has defaulted, wherever that money must have been utilized in the entire channels, the attachment can be made possible by the enforcement directorate by proving the lack of bona fide or asserting that this was a dubious transaction or it was just to park the money defaulted from the bank. Whereas the situation could be, now you see the situation. On the one hand, the proceedings under the scheduled offence are running at the speed of bullock cart. On the other hand, the proceedings under PMLA will run at the jet speed because that FIR filed with the CBI or UW will walk slowly. Scheduled offence is yet to be proved there. Forgery has been done is yet to be proved, because a bank loan may go bad for multiple reasons. Forgery or cheating is just one of the reasons. Other reason could be genuine business collapsing, business decline, business loss, business judgment error. So that is altogether a different reason, and that will be proved in the court of law. But before that could be proved, ED's cases start at jet speed, and because of the jet speed, what happens? I mean, the actions are done under PMLA. So here comes the role of chartered accountants in understanding the way the money trail, financial trail can be explained. Here comes the lacking. As I said, the beauty of this law is that this cannot be handled by a single professional. Meaning thereby, a criminal lawyer alone cannot handle it, civil lawyer alone cannot handle it, chartered accountants alone cannot handle it, company secretary alone cannot handle it. So combination of lawyering and support mechanism is required. So here comes the role of the chartered accountant to make out the financial structure, how the transactions have been done, how the money has been utilized, so that the rigors of the actions can be downsized and the special courts can understand, the tribunal can understand the nitty-gritties of the situation and can decide the cases in a proper judicious manner. But criminal lawyers are not able to do that. That is also one of the reasons that they themselves are not able to understand. They were not able to make the judges in turn understand properly, and therefore the honorable judges were also not feeling very comfortable in granting bails, because the requirement for bail related provision is that the judge should be satisfied that no offence of money laundering has been done in this case. So they are talking about prima facie satisfaction. But for prima facie satisfaction also, there should be some basic understanding, and for basic understanding, the understanding should be with the professional. So therefore there comes the role of the chartered accountant. I had tried to articulate the way how the pursuits of crime can be worked out by a chartered accountant, as I mentioned here, that by taking these steps, finding out the sources and quantifying amounts of proceeds of crime from the commission of an offence, identifying the proceeds to be attached acquired with POC, identifying the source of such properties and connecting it with the POC, identifying loan utilization in the attached property, calculation of the correct value of POC, valuation of the property attached in comparison with the alleged POC, proper financial accounting analysis, preparation of money trail for the attached properties to demonstrate the source of funds. So here comes the role. So therefore our awareness about these subjects will also help us become contributory in one of these areas. So now with regard to, before I come to Benami, with regard to money laundering, anything else comes to your mind? I think one prominent issue which is left to be addressed here is if during the course of money laundering exercise, during the course of doing transaction, if any transaction happens with any person who has done money laundering or any property which was involved in money laundering, what will happen and what should be done? Even if you are simply selling a property, should you be concerned with any process of money laundering? Simply selling the property. You would say, sir, why should I be bothered? Because when I am selling the property, I am simply getting the money and giving the property. What if money is tainted? Maybe from committing bank default, he has given money to you. And ED on the other hand is finding the trail. So trail will end in your bank account. Now you will say in return, sir, I have sold the property. They will say, okay, forget about the property. We are concerned with this money. This is bad money. What the position of law is in this regard? Sorry? Institutional? Yes. That is what should be done. But what is the position of law? How it will happen? Who has to prove what? Burden is upon whom? It is whose burden? You have sold the property, the burden is upon you. So you will be able to prove that the money which you have received from the buyer is a genuine money. How would you prove? You were not even concerned with that. You did not even think of that. So this has become very, very crucial and burning issue today. Now, I am not saying that there is no support mechanism available under the law. But believe me, it is available only to those who have been quite diligent and vigilant in their conduct while doing the transactions. For example, here the situation has to be explained like that first of all property has been done and sold at arm's length principle. And while you are interacting, you have to show that you are not aware at all that he has done some bank fraud, or he has done some offences, or he is in a rush to park his money somewhere, etc., etc. Therefore, in many of the cases, my clients, whosoever is selling the property, are requesting me to draft a kind of undertaking to be signed from the purchaser, that this is a good money, this is the source, blah blah blah. I hereby undertake to indemnify in case anything is found wrong with respect to the certificate that it is a good money and what are the sources, etc., etc. Earlier, nobody bothered. And now let us take the reverse situation. Suppose you are the purchaser. Should you be bothered?
What if the property was acquired to take
It has happened, madam. I had to go to file writ in Delhi High Court and to do lot of things. For example, in a bank, a person defaulted, properties were mortgaged, he purchased those properties under SIRC. And when he went to register the property, the ED has already attached it. Now the burden came upon him to prove that this is genuine transaction. If the property was, you can do this property, but be ready to do fight. Either you are getting at half a price that you are ready to do the litigation, or be doubly sure what property you are buying, what kind of undertakings you need, what kind of due diligence you need to carry out. So kindly see that you are required to now have the knowledge of this law, not because you are doing in any money laundering activity, but because you do not want to be unnecessarily get stuck. So a person's wrongdoing, another person's wrongdoing can also make you liable for an action. And that is how, sir, when I came back from the tribunal, I wrote one article when I analyzed the law like this, around in 2018 I wrote this article, and the title of the article was, if you live in India, you can be held liable for an offence which you have not committed yourself. And it has been published in an international tax journal. Yes, sir.
One question, you said about purchasing a property which might be tainted. So when you you said the money laundering, they go on a trial. So I have paid the consideration and I prove that it's the consideration paid is parent material. So when they go by the trial, then they have to go behind the consideration, not the property, because property is already passed to me. So how can the property still be attached when I have paid the consideration?
So, so it acts both ways. They are in search of properties also. If the properties are involved in money laundering, they are in search of money also. Suppose from that money the property was purchased and that property I have purchased, so then they will be following the property also. Because of this improper drafting of section 21U, that equivalent property they are in search of. Suppose that property, proceeds of crime, they are not able to trace. So any other property of the money launderer, they will attach. And if I bought that property and if they find the transaction is not above board, they will attach that property. And that is what is happening. So examples before us are quite large in number. You can take example of Jacqueline Fernandez. What that poor lady did. Did she do something wrong? Only thing was she fell in love with the wrong person. That's it. That was her mistake. So when she met first time, so we simply suggested that you simply say this, कि when Suresh Chandrasekhar has conned all the best of the investigation agencies, elite investigation agencies, I am just a poor lady. He could have conned me easily. And why are you blaming me? Why are you rather it's a double whammy for me. On the one hand, I mean, I am emotionally burnt and broken, and then you want to hit me legally also. So, but she had to stand in a witness box to clarify transactions. What transactions you have done? Her attachment proceedings are going on. Earlier she was made as witness. Now she has been made accused also, rightly or wrongly. Let us do not go into that because its matter is sub judice. But see, so I remember those words which we used to hear from our elders, that you have to keep a good company, that you are sum total of the 5 persons around you. So all those words which we have been listening from our elders and the spiritual sayings that coming truth. Now, as I said, most common ingredient found in violation of laws related to economic offences is that transactions done are Benami. That is a finding of the new investigation agencies. And that is why we need to understand, and there is a lot of emphasis on enforcement of this law. So if we want to understand in a very, very crisp manner, in one line, that what exactly is a Benami transaction. So I would make an attempt to explain with the help of this slide. That suppose there used to be only one person at a time, that in any given situation with regard to a property, there is only one person behind it, if there is one owner. That is, if B is holding a property, then he will be in the picture, not more than that. But in a given situation, if Mr. A wanted to buy a property from Mr. B and he sends money to Mr. B with a request that please transfer the property, execute the conveyance deed in favor of Mr. C, and he does it like that, and he enters another arrangement, tacit arrangement, unwritten arrangement with Mr. C, you keep the property for my benefit, for my control, my usage, my dominion and control. Whenever I want to use it, I will use it, but it will remain registered in your name. Now B goes out of the picture, two persons comes into the picture. A, who is a real owner, who is a real beneficiary, usage, and C, who is an owner in the eyes of public, in the eyes of law, apparently. So one person goes out of the picture, two persons come to the picture. So duality happens. So whenever ownership is divided into two parts, duality comes. And the moment duality comes, Benami checks in. That is a fundamental concept, to make it very easily understandable. Yes, sir. Somebody say.
What if he holds the property for A without registering it as a beneficial owner?
Yeah, that will be a different example. I am trying to help this example also, but in that case also, if B continues to hold the property and he has already received money also, it will also be a Benami transaction. Some people were saying when he purchased originally property, it was not Benami. I say no, please do not get confused. At any stage also it can become Benami, because in many cases it is happening. In particular in the case of shell companies and all that, this argument is coming in defense, but that is not a solid defense. Because it is not necessarily that later on it cannot be Benami. A person is good, it is not necessarily he will always remain good. He can be turned into bad also. So duality comes in, Benami checks in. Now I will give you another example. You must have heard the word Advait, right, in our spiritual philosophy. So long as I treat myself as part of him, remain connected with him, it is a situation of Advait, singularity, no duality. I do not feel any problem in life. Problems would come, will go. I will not feel them much. But the moment I disconnect myself, bring in duality, 2 instead of 1, from that day onwards the I will start problems and ups and downs of life in a different fashion. Same concept. Duality comes, problems comes. Duality comes here in ownership, Benami comes. The reasons could be fraud on creditors, tax evasion, black money, corrupt practices, could be anything. Much more than that. As Vasu sir told us that there has been history behind it, customary practices have been there to do Benami, but the government has suddenly come up with the explanation that no means no. So whether for the right reason, for the wrong reason, if there is a Benami, it is Benami. Now this has been divided into 4 parts, Benami transaction. Part A, Part B, Part C, Part D. Part A is which I have already discussed. Part B, if the property is held in fictitious name, if I have kept the property in the name of some god, goddess, law considers it to be fictitious, there is nothing doing, it's gone. Part C says owner is not aware of the ownership, denies ownership, straight away Benami. Somebody says, sir, sorry, is it in my name? I am not the owner, I do not know about the ownership. Government says, okay, it's not your property, it is our property. Under section 29C, forget about it. Part D is where lot of actions are happening by the income tax department invoking clause D, where they failed in invoking section 68 or 69 of Income Tax Act, which says if the payer of consideration is not traceable or is fictitious, then it will be liable to be attached as Benami property under section 290 and then confiscated immediately thereafter. So these are 4 parts, and believe me, these 4 parts are so omnibus, so sweeping, that all possible situations of a Benami, property being Benami in any manner have been covered here. Whatever cases have been brought before us, they are Benami somehow, somewhere in A, B, C or D. Any exceptions? Yes, but very few, and that too only in Part A. What are the exceptions? If property is registered in the name of a person who is acting in fiduciary capacity, for example, director, etc. A definition is not exhaustive, so it is also prone to litigation. Karta. Look, in this case, what has happened is many people have different kind of tensions and stresses. Different people having different tensions. So keeping in view the tension, only questions will come up in the audience, from the audience. So first tension would be of a kind that lest my Benami property is not detected. Another bigger tension is that lest my Benami rishta is not detected. So comes the questions also. So somebody from the audience asked me once, ki sir, spouse is alright, but whose spouse? So I said, don't be so excited. In the slide it is not mentioned, but in the law it is mentioned his or her own spouse. Then the immediately question comes, a child means what? So it is written any child. But what I mean to say is not what you are thinking. My question is child up to what age? So child is child according to my understanding of any age. Last exception is brother, sister, lineal, descendant or ascendant. If you buy property in the name of mother or brother or sister, these 4 categories, whether it will be Benami, because it is an exception, yes, it can still be in Benami if it is buying is not in joint ownership. So if you want to buy the property in the name of mother, retaining you as owner, then you have to be joint owner along with them. Otherwise, you buy property in the name of mother and continue to show himself as your owner. Government says it will be Benami. Maybe brother. Cases are there. Two brothers living together. One is on first floor, other is second floor. First floor has been treated as Benami because registry was entirely in the name of two brothers, in the name of elder brother, because of the reason that younger brother is continuing himself to be showing as owner of first floor. So it is essential that we know that only these are the exceptions, nothing beyond that at all. Anything other than this is Benami for any reason whatsoever. In the name of mother, they say simply it is based on the concept कि if you want to do something, do with heart, with sampurn bhav, complete surrender, complete faith. If you want to buy property from mother, okay, gift it to her, let her buy it, or you buy it in her name, but forget about your ownership then. So any distinction between what you are doing and what you are showing, if there is any distinction between the two, Benami checks in. No, under the gift, suppose I give gift to my mother and she becomes the registered owner. There could be two ways of doing it. I give the money, gift it, and she buys, or I gift my property to her. In any of the cases, if she is a full-fledged owner, there is no problem. If she is only a registered owner, again there is a problem. Yeah, it will not. Yes, it will not, because in that case, I have given it totally. There is no distinction, there is no duality happening. That is what government says. So we will not allow duality, that is what is being conveyed through this law. Then these are the authorities. As you see, every state capital has one BPU, Benami Prohibition Unit. Delhi has two BPUs. Here I think there is one BPU in Chennai, or two, I don't know, only one. So Delhi 2 BPUs, Bombay 2 BPUs, Calcutta, Chennai, I think they have one BPU each, Bangalore 1 BPU. Everywhere else, I think it is one BPU only. And then above that is approving authority, and then above that is adjudicating authority. It is not CIT appeal, it is adjudicating authority, which is competent authority for NDPS, SAFEMA, etc. And above that is appellate tribunal, not the income tax appellate tribunal. Appellate tribunal of PMLA and Benami and SAFEMA, etc., whose principal bench and the only bench is in Delhi. And headed by Honorable Justice M.N. Bhandari, former Chief Justice of Madras High Court. He is the chairman of appellate tribunal. And many cases are coming. Recently, I argued one case of Mr. Ajit Pawar, which was talk of the town on the day when he took oath. So, the Honorable Tribunal has held that though no link with regard to the payment by him has been shown, it's a detailed order. It's worth reading. It's available on the site. You can read it. Then many fundamental questions are arising. I will get this slide circulated, and I will take up one or two questions which are of very prominent nature. Like, first question is whether this property, whether the Benami transactions can be covered on old transactions, whether it is retrospective. I have another question before I answer this question. Whether there is any time limit in future during which the action can be taken by the authority. Say, for example, the transaction has been done today. For how long, in how many months, years, decades, lifetimes, the authorities have the power to take action? Any idea? 16 years. ये ज़्यादा से ज़्यादा बोला है आपने, काफ़ी कुछ सोचने समझने के बाद, राइट? श्री कृष्ण, what did he say in Gita? समय अनंत है, ना इसका प्रारंभ है ना अंत है. Time has no beginning, no end. So they said, why to bind it with time? No time limit has been given for any future action. No time limit for past has also been given. Only thing is, Honorable Chief Justice, former Chief Justice M.V. Ramanna said, no, it cannot be applied retrospectively. And this judgment was not liked by the later Chief Justice, that is Honorable Justice D.Y. Chandrachud. He said, no, nothing doing, let us review it. So half a page judgment reviews the well-established earlier judgment. Welcome to the world, new legal era. So nothing is permanent, right? As we say in life, so like nothing is permanent. कुछ भी रुकता नहीं है, समय बदल जाता है. And other thing is, everything is interconnected. And these laws have established that everything is interconnected. Like you touch one aspect, and I do not know how many laws will be attracted simultaneously, suddenly. Just do small mistake. Whether tax-paid money can be used to do Benami transactions. Suppose I earn rupees 100, pay tax of rupees 30, 70 rupees is my money now. And I want to buy property in the name of my friend as Benami, declaring it as Benami, ki my property, I am buying it in the name of my friend. Am I allowed to do that? Because people are vociferous, sir, what is the problem? It's my tax-paid money. So government says no. And there is a logic. If the government does not want Benami to happen in life, they can stop it. Otherwise, I will say, okay, I have earned 70 rupees. So can I do illegal things from that 70 rupees? Say bribery, say gambling, say ransom, supari killing. I mean, can I do? No. So that is why, I mean, though somebody say ki Benami is not that heinous, but probably government has considered to be that much heinous. And that is why people are being denied bail. So right or wrong, this is the message. We have to pick it up as it is. Understand and apply and reset our life accordingly. Believe it or not, fact is a fact. Whether U-turn is allowed. I have done Benami by mistake. I will say, sir, let me correct it. Don't take away my property. They say, no, no U-turn allowed. Because of section 6(1), which says transfer of a Benami property is void. So I am not even allowed to make corrections. They say if it is Benami, it has to go to the government. What will happen of the bona fide purchaser in this case? Very, very ticklish issue. Here section 27 gives the benefit, but the burden will be upon the bona fide buyer to prove 2-3 things: that he did not have any knowledge of Benami transaction, and he had paid full value of consideration, and one more condition is there. But before I come to that, how shall you prove that you do not have knowledge of Benami transaction? By your conduct. Suppose the property is worth rupees say 50 crores and you are dealing with the driver of somebody who does not have in a bank account hardly 20,000 rupees per month, which was within your knowledge, or you somehow came to know because you are dealing with somebody else, driver, gentleman you could not even recognize. If you ask, okay, from whom you have bought the property, you are not even able to recollect the name and give his hulia and description. So that means you are dealing with X, buying property for Y. That means you had the knowledge that this is some hanky-panky property. Property was for 50 crores, you bought it only for 20 crores. So it will be difficult to prove. Therefore, from this angle also, it is necessary that while buying the property, you have to do some due diligence exercises, lest you end up in buying a Benami property and you are not able to claim the privilege of being a bona fide purchaser as well. And whatever I am discussing is the law. Welcome to the new legal era. I am not adding something from my own. I am not scaring. I am just showing the law so that we can realign ourselves. Because somebody was saying, sir, I am very afraid after the lecture. I said, I am making you aware, not making you afraid. Awareness and afraid is different. If you are aware, you will be able to tackle this, handle it well. If you want to remain in some other paradise, it's your choice. No future time limit. Any property, it covers the wildest possible definition of what property is given in Benami law. Any profile, even listed companies are being hit very badly. Land bank companies have been hit very badly. Land bank, because infrastructure company cannot create its own land banks. They have to depend upon many other companies who create land bank for them. In certain cases, in a given situation, these have been treated as dummy entities, and properties acquired by them has been treated as Benami land bank. Even corporate, non-corporate, all have been covered. Look, people say, sir, I did not have any bad intention to do Benami. You know what is the response? We will see you in section 53 while we will prosecute you, but the moment it is Benami, you admit it, property becomes the property of the government. And you know who all are liable for prosecution? What are the consequences of Benami? First of all, property becomes the property of the government. Fine 25% of value of the property, and also prosecution. You know of whom? Of three categories of persons. Two categories you will immediately understand, Benamidar and beneficial owner. There is one third category. Person who have abated in happening the Benami transactions. In one case it happened, he said, Lalaji, why did you do this transaction? He was a biggest businessman of the city. This case was from Raipur. So that businessman Lalaji said, sir, because my CA told me to do it like that. So interrogation of CA started. And when the search happened in CA's premises, क्या बोलते हैं उसको? DSCs, digital signatures. They were found in the drawer. He is filing the return. He is doing everything. He is just signing. So we have to learn now to do the transactions at arm's length. Deal with our clients at arm's length principle. It's a small thing for us. Sir, DSC तो पढ़ेंगे होंगे हमारी drawer में उसमें problem क्या है? We need to address a separate seminar on this topic itself. If you want to remain away above all the possible litigations which your client may suffer. What is to be done? Sorry? This is a cardinal issue which you are raising, on which we need to do some thinking because of our being associated as auditors also in some cases. So it can be divided into two parts. What will be the implications with respect to being an auditor, NAFRA, etc., and consequences, direct consequences under these laws. Mere knowledge, whether it will be liable for prosecution, it will be a very, very thin line, because it will not stop at mere knowledge. It will also proceed maybe a bit towards association also in the doing of the transactions. So walk very carefully, tread very carefully, and we can discuss it on case-to-case basis. My slides can be distributed. Whoever is sitting from SIRC, slides can be distributed, no problem. So I can skip some of the slides. Multiplier effect, as I said. If wrongly attached property later on released, somebody said, okay, give me the compensation. There is a specific section which says no compensation. Government does not do anything wrong. By chance you are not proved to be wrong, that is a different thing. No compensation. So small interplay I will give with income tax law. There is a strong interplay. In one case, what happened with this, what happened, you can understand that he made a surrender during the course of income tax search of rupees 10 crores. Out of rupees 20 crores, 10 crore was on account of bogus share capital. He said, okay, I have paid tax on 25 crores, matter is over. But matter was over for few months only, because immediately after 1 or 2 months, he received a notice under section 23, read with section 19 of Benami Act, calling him for recording of statement with regard to this transaction. So raising his collars up, he went to visit the officer under Benami law, and he started asking the question, ki, you said that this is bogus share capital received from B Limited, you are Mr. R and received by your company R Limited. He said, yes sir, I have paid the tax also on that. I said, okay. That means before receipt of check from B Limited, you had handed over cash to B Limited of rupees 10 crores. Now sudden silence is there. Suddenly as if something has bitten him. Okay. And then from this check, B Limited gave to R Limited, and R Limited in turn issues shared certificates to B Limited, which B Limited is holding, and that means apparently is holding in Benami capacity, because you must be exercising full control, because you have exchange cash and check. You know what did he do? He made attachment of A, shared certificates, B, the amount lying in bank account of R Limited, and some amount was spent in utilizing construction of office building, that also attached. Three things he attached. Is the action justified? Now, because of these facts, actions have to be done. Only controversy or only debate, only fight can be of what is liable for attachment. According to my understanding, only shares, but department is attaching all three. In this regard, I had written one article again on this topic, and the title of the topic was how long menace under section 68 and 69 of Income Tax Act shall continue to haunt the people under Benami law also, and that is what is happening. Then even in this international transactions, Benami can check in. If entity established in Mauritius are established to be paper entities invoking GAR or PPPT test, so Benami checks in. Then SBO concept, significant beneficial ownership details are required to be given under corporate laws. The moment you give this information and you are admitting somebody else to be the real owner, registered shareholder is somebody else, then it can be fodder for the under Benami law. Somebody asked me, sir, I am declaring that should be the end of the matter, I am complying the law under SBO, section, what is that, section 190 of Companies Act. I said, hold on, you are saying that you have declared that you have jumped the red light. Okay, so that means no challan. Declaring is only transparency. Now, what will be the consequences of the same? That the law will take its own course. It's not a clean chit. SBO is not clean chit. SBO is a information gathering process which you have gathered and given. Certain good judgments which happened. One of the judgment is the last one, Pamela Bhardwaj, which we argued around 2019. Hardly 4 or 5 judgments were available from the tribunal, in which we were arguing that burden to prove should be upon the IO, and bench accepted. That burden to prove under Benami law is upon the IO. So whatever cases I am getting from many people, my brothers or sisters would come to discuss with me, those who are well versed with tax practices. Small problem which I face is, this law is being handled as if this is a tax law. But there is a lot of difference. Only thing common is some officers of the income tax department are deputed to administer this law. Beyond that, there is nothing common. BPU is in the same building as of income tax department. Other than that, there is nothing common. Authorities are different, laws, fabric is different, concept of burden of proof is different. So must be the difference in our defense mechanism. This I am speaking. Then people buying land, NRI buying land in the name of Indian friends, treated as Benami because of some admissions, and the treatment is going on of Benamidar and Benami property. With regard to Black Money Act, I will take only 2 minutes to explain 1 or 2 things which can be summed up. That if any person is having a bank account abroad or any other asset abroad or any financial interest in any asset abroad, that must be disclosed in the income tax return under FA schedule. If he is having any income abroad, that must be disclosed in return in India so long as he is resident here. If that is done, Black Money Act will remain away. If it is not done, it's more disastrous than PMLA and Benami. Because here the beauty is that it can be taxed in the year in which comes to the notice of the IO of the AO under Black Money Act. If it comes after the notice after 50 years, he can take action after 50 years. That is problem A. Problem B is far more larger, that the valuation will be done of that year, in the year in which it comes to the notice of the assessing officer. Because they want to charge the benefit of, the money. Suppose today you should have paid tax, you did not pay tax today. So if they come to notice after 20 years, so 20 years you enjoyed that money on the tax. So they say, no, you cannot. You pay back us also. We are also partner in your growth. So they will be charging on that valuation. Very harsh. Very, very harsh. So situation which we are facing today is that the cost of non-compliance earlier used to be very lower compliance higher. Now the cost of non-compliance is very, very high. And because of this high cost of non-compliance, it becomes impossible to think of non-compliance.
What is the technical omission, sir? Yes, not the RBI fundamental technical, but you have failed to disclose it in the income tax return.
No, technical violation is only with regard to RBI non-approval. But who prevented him to disclose in the income tax return? So show it that it was, whichever year invested, show, returned, show, that's it. Who stops you from showing? However, I will give you one other, if you are sincerely asking this question, one other insight into it. If you read the definition of undisclosed foreign income and asset, you will find in the text portion there is nothing like undisclosed. Undisclosed foreign income and asset will be decided on the basis of explanation, its availability to the satisfaction of AO or its absence. If you can explain, satisfy the AO, it should not be. But the person will remain liable for non-disclosure penalty of rupees 10 lakh. And AO's discretion, I do not know how will you handle the discretion of the AO. I think the most toughest thing to handle on earth, the discretion of the AO. In a hearing before Supreme Court said, "Yeah, why are you arguing before us like this? Go back to the department, handle, satisfy the AO, and send back the matter." So, this is a situation before us that the cost of non-compliance is really not unthinkable. And that is why I was sharing in the beginning itself that it's a new legal era. We have to reset and realign ourselves. Coming back to the original thinking which we were talking about, what will happen, whether there is any commonality between law and spirituality. Just my thoughts I am sharing, maybe it may be of some thinking later point of time. When we record statement, even the recording of the statement happens with the words, statement on oath. And in oath, whom we remember? Our core, in fact. Achha, look, one more experiment I am giving you. You read IPC, read any other law. For example, read IPC which says theft is bad, fraud is bad, cheating is bad, threatening somebody is bad, slapping somebody is bad, killing somebody is forbidden, etc., etc. You read matrimonial laws based upon fairness, equity and justice. Read environmental laws. So one thing comes to us which says is something like that in case divinity would have said something tangibly for our good life, would have said all those things, or something which they could not have said as tangibly, could not have appeared before us for various reasons. So they took help of legislations, conveyed it through them. You pick up any piece of legislation, if that has been drafted with pure soul and mind, without any agenda, and it will give a reflection of what divinity is trying to say. So, anybody who is spiritual in nature, you will find that without reading the laws, he is doing something which the laws have prescribed, and he is not doing something which are forbidden in law. I will say conversely now. It will be more logical for we legal persons to understand. Somebody who is following the law with heart and soul, not just to show the compliance, when he will become spiritual, he would not even know how easily, how smoothly, how fast he will become, if he is following the law to the T with heart and soul. So with this message, and the message that from Benami, what I have understood is, what they are trying to give the message is, that this law is telling us to do something and to remain abstain from something, that whatever you are inside, be from outside the same. Same, inside, outside. Whatever is yours, think that only yours, nothing else, and convey others also that only that is yours. Something that is not yours, do not claim that it is yours. So get rid of Benami life and get into real life. Thank you very much. Any questions are most welcome.
Spoke about that Benami transaction between relatives.
Hello. You were telling about that Benami transaction between brothers or between mother and son. Say, for example, father holds a property, and we have seen cases where father holds a property, but the rental income is admitted in the wife's name or in the daughter's name just to evade, say, the tax evasion or the GST. Does this come under Benami transaction?
Maybe it doesn't. Very self-admissions. So self-admissions will really create trouble. Self-admission. Don't do that. That is why I am saying now let us straighten the life. Reset, realign our life. Consequences are dangerous. You are taking small panga. The small panga will, I don't know where it will take you to. Sorry?
Spouse is not a problem.
With spouse also, situation is that first of all with regard to child, it has because you want to claim that exception, that is why you are saying. But the embargo is that it should be from known sources. The property should be purchased from known sources. If it is not from known sources, the burden will come. You could declare, prove where from it has come.
My question was, source is all clear, sir. Say a husband is holding the property, just to come out of the ambit of GST. So what he does is he shows the income under wife's name. So wife receives the income, wife admits the income under income tax also, but property remains in the name of the husband.
No, but why would income tax department allow you to do that?
Would not. I'm telling you, will the Benami thing come inside?
So it will be Benami, but you will have to claim benefit of exception under section so and so. And the problem will be under income tax law also. So I would not advise to do like that.
Sir, the spiritual person happens to purchase the tainted property.
Which person? Okay.
Spirituality and all these acts, the moment he is following spirituality and he gets rid of all that, but so with due honor,
So that
so
is why
it happens to.
that is why spiritual divine powers do not come tangibly here. They say we have said something which is in the law. Read the law. That is the law of the land. And my law you will follow only when you are able to follow the law of the land. You are not follow the law of the land, the law will take its own course. Spirituality also washes off its hands. Law of the land has to be followed. What will happen in prosecution, at that time court will decide. But other consequences are imminent.
Any chance that Spincy is following spirituality, so he may not get into all these situations?
No such, that is what I was saying. I think sir will speak better on this aspect. So, no exceptions have been created, unfortunately.
No, law is law, but whereas I thought that you may come out with the explanation that since he is following spirituality wholeheartedly, so he may not get into a situation where that the question which I asked may not rise. So if he purchase the property, then he has to face the music.
No, look, because of his bona fide, he can prove that he did not have knowledge of Benami transaction, etc., etc., which is available to any person, not because he is a spiritual person. I don't want to speak much on this here. So, to end it on a positive note, yes, sir.
Is there any threshold limit for all this?
No threshold limit. So, because in his eyes, everybody is equal. So, no threshold limit.
So when we are handling this 68 and 69A, there is a chance that we may have to face this Benami Act. Yes.
Yes.
So it's not that we are admitting IT and coming out of that.
Yes, yes. That is what I am saying. That continue to haunt. Please read that article. So it will, many other things will depend upon the many other questions. How the things will happen, what not happen, who has given what, whether it will be covered under 68 or it will not be covered under 68 but will come under Benami. So whole lot of permutation combination we have to between. I have given the broad coverage today. So the proceeds of Benami property are also Benami property. So he can be covered under proceeds. That is the problem. Proceeds can also be attached. Property can be attached, proceeds can also be attached.
Sir, I have a case where company incorporated over 35 years. And many of the old promoters, they don't know where they are. In fact, they don't know whether they are there. We still go by what was the list of members as originally incorporated. Now my question is, we don't know whether this is a situation. We don't know. Let's say 5 promoters, whether they are there or not, we don't know. If they are not there, who are the legal owners? I mean, legal still we don't know. I just wanted to know what risk is the company holding under the Benami law.
If it is proved that somebody else is enjoying the profit but not the company, then there may be a problem.
Okay. But other than the company. But as of now, fortunately, this company is not declaring any dividend. So they continue to be in the list of shareholders, their name, irrespective of whether they are alive or deceased, irrespective of whether.
So long as the property is within the domain and control of company, no problem. But the certain other facts come up, it may be a situation.
Okay, right.
Sir, after transmission of shares, automatically the legal has become the
Become the
owner.
owner.
Therefore, it is only legal act. It's not the act.
No, correct. But the question is again whether we don't know whether the name of the shareholder.
On behalf of SIRC of ICAI, I thank CA Advocate Ashwani Taneja sir for such a wonderful and insightful section. Your expertise and engaging delivery made it truly enriching for all of us, sir. I now request CA Vishnu sir to kindly present a memento as a token of appreciation. Thank you, sir. Yeah, I once again like to thank Mr. Advocate and CA Ashwani Taneja sir, and also all the members for their active engagement. We hope you find this section enriching and look forward to welcoming to future programs. Thank you.